This is a part heard application and appeal in the matter of R and the First-tier Tribunal and another.
Yes, Mr. Butler.
Thank you, my lord. If I could please pick up on the question of direct attributability
Yes.
that was raised by my Lord Justice Singh yesterday. Could I please hand up three authorities which are relevant to that issue? Three documents. One is Section 15 of the Tribunals, Courts and Enforcement Act. The second is the case of Bradbury, which deals with the interpretation of Section 31(2)(a) of the Senior Courts Act. And the third is a case called Gover, which I'll come to.
Right.
Could I please make 5 points? The first point is to look at the function of the Upper Tribunal. And Section 15 of the Tribunals, Courts and Enforcement Act applies Section 31(2)(a) and 2(b) to judicial reviews in the Upper Tribunal.
Yeah.
So, the Upper Tribunal must refuse to grant relief if it appears to be highly likely that the outcome for the applicant wouldn't have been substantially different if the conduct complained of hadn't occurred, unless it considers that it's appropriate to do so for reasons of exceptional public interest. That's the 2B bit.
Mm-hmm.
That function, in my submission, should be exercised with restraint because a judicial review court should be wary of trespassing into the forbidden territory of predicting what the decision maker would have done, and because highly likely is a high threshold. And it's on that point that we put in the Bradbury against Brecon Beacons National Park Authority case.
Yeah.
My Lord Justice Singh, I know, will already have heard what I'm about to say about this. Very briefly, the National Park Authority had omitted to obtain certain assessments before granting planning permission. As it turned out, the assessments came to the same conclusion as the planning committee, so in that case, the absence of the assessment made no difference. But what I wanted to show the court was the general guidance that the Court of Appeal gave on how the Section 31(2)(a) highly likely test should be applied. And if we could look, please, at internal page 15. This is part of the judgment of Lord Justice Lewis. If I could ask the court, please, to read paragraph 71.
Yeah.
And then, please, at the top of page 17, Lord Justice Lewis underscores the point he makes at 71. Third line, there's a sentence beginning, the section emphatically doesn't require. If you could please read from there to the end of paragraph 74.
Mm. Yeah.
And then finally on this, if we could turn back, please, to page 16, at paragraph 72, there's a citation of the Court of Appeal's judgment in the Plan B Earth case. And could I just ask the court to note indented paragraph 273, where the Court of Appeal made the points that I've already identified on separation of powers and highly likely being a high threshold.
Which paragraph are you reading from?
I'm paraphrasing what is said at indented paragraph 273 on page 16.
Yes.
So that's the section 15 function that belonged to the Upper Tribunal.
Does it make any difference that these authorities appear to be concerned with the classic situation of judicial review by a court of an executive body?
In my submission, no, because the first...
In the present case, although it's judicial review, it's effectively an appeal on a point of law from a lower tribunal. Does that make any difference?
In my submission, it's no different, because the First-tier Tribunal is charged with making a full merits decision on the facts in exactly the same way as a classic administrative body is. So that's my first point. My second point is that CICA didn't rely on section 31(2) capital A before the Upper Tribunal.
I thought I saw a reference to it somewhere. Was it perhaps? No.
I made the submission orally to the Upper Tribunal that CICA's submissions on the facts could be characterised as being a 31(2)A issue, but that wasn't a submission that was advanced by CICA. They didn't say this is a 31(2)A case, even if you find against us.
Why does that matter? Let's assume you're right. Having heard Mr. Moretto, he'll reply on this if he disagrees. But let's assume you're right. Why does that matter?
It's a factual observation. I predict that what my lord's about to say is that the Upper Tribunal, applying section 31(2)A, should do so of its own motion if the terms of it are met.
And if this court, and I emphasise, we haven't reached any view whatsoever. We're just testing the points.
No.
But if we reach the stage of the analysis where otherwise we accept your submissions on the interpretation point, but we conclude that it would have, it's abundantly clear that it would have made no difference to the outcome in the FTT, then why should we hesitate in deploying section 31(2)A?
Well, in my respectful submission, this court doesn't have the 31(2)A function.
Oh, I see. Right. What's the legal basis for
Well,
making that?
in my submission, this court would be asking itself whether the Upper Tribunal erred in failing to apply 31(2)A.
I thought we had the same powers as the Upper Tribunal on appeal.
Well, if the court were redetermining the claim for judicial review, I appreciate that if this court concludes that the Upper Tribunal fell into error,
Then we can remake the
then you
decision.
should remake the decision. But in my submission, this court doesn't have, as it were, an originating section 31(2)A function.
But what would stop us from saying, well, the Upper Tribunal was wrong in its interpretation of the phrase medical condition. But we know on the facts found by the FTT that changes were not directly attributable to the index offence. Therefore, we remake the decision that the claim overall fails on that basis. Anything legally impermissible about that?
Well, I'm going to come on to this in a moment, if I may, but if this court concludes that the Upper Tribunal was right on the question of medical condition, then it was right to allow the claim for judicial review, subject to the section 31(2)A question.
Or perhaps also subject to whether it was a material error of law.
Subject also perhaps whether it was
Because
material.
that principle would be applied even before we had section 31(2)A.
I accept that on the simplex basis.
Well, it's not even. I'm not entirely sure that it is simplex, but it's often with simplexes in the field of discretion.
Yes.
There's often an anterior question: is it actually a material error of law? Is it a technical error?
I understand the point. I'd like to, if I may, take this point in stages. My second point was simply a factual observation rather than trying to say that there's any bar as a consequence of it. As a matter of fact, CICA didn't rely on section 31(2)A before the Upper Tribunal.
No, their point
I'm
was
so sorry.
their point was it wasn't a material error because of the finding on direct.
Yes, in fact, I've just been corrected, and it may be, after all, that this is just a bad point altogether, and that CICA did, at least in its pleadings, refer to section 31(2)(a). So could I, apologise to the court and ask that my second point be scrapped, and actually I have 4 points on direct attributability. So now what is my second point is that the Upper Tribunal did, in substance, address the section 31(2)(a) question. And could I please show the court why I say that? If we could turn up the core bundle. At page 131. I could ask the court please to read paragraph 6 of the Upper Tribunal judgment.
Yeah.
And in my submission, it follows from that, inevitably, that the Upper Tribunal didn't think that it was highly likely that the outcome for LXR wouldn't have been substantially different if the First-tier Tribunal hadn't misdirected itself as to the meaning of medical condition. It might have done. So the Upper Tribunal thought. Now, in my submission, the section 31(2)(a) question, or the question of materiality, was one of evaluative judgment on which the Upper Tribunal is entitled to some leeway. It can't be impugned simply because a different court might have reached a different view. And in my submission, the Upper Tribunal's conclusion at paragraph 6 was one that was open to it, based on what the First-tier Tribunal said at paragraph 50 of its decision. If we could please turn that up, page 25.
Just before we leave 6, the link there to attribution, would the validity of that conclusion be dependent upon whether there was evidence to link the subject matter to attribution? In other words, the dealing with the repression point and becoming aware of what had happened and the significance of it in 1998. Would there have to be evidence linking that to the attribution issue?
Well, the Upper Tribunal is conducting a judicial review of the First-tier Tribunal's decision, and the First-tier Tribunal had made a finding of fact that there was a change in understanding of the condition. And then, as I'm about to show the court, it then dealt with the question of attribution. Now, what the Upper Tribunal is concluding is that the First-tier Tribunal was wrong to conclude that change in understanding was incapable of constituting a change in medical condition. And the Upper Tribunal is paragraph 6 saying that had the First-tier Tribunal not made that error, it at least might have reached a different view on direct attributability.
Yes, I'm just wondering whether that line of argument depends upon the appellant putting forward evidence or a case that it was relevant to that factor.
Well, in my submission, no, because unless somebody in the Upper Tribunal was impugning the validity of the First-tier Tribunal's findings of fact, or suggesting that the findings of fact meant something different from what they appear to say at paragraph 11. So, what I was going to do then was to turn, I've made the I've in advance made the submission that paragraph 6 was a conclusion that was reasonably open to the Upper Tribunal, and to support that submission I was going to ask the court to look at page 259. And we've already looked at this, the first sentence of paragraph 50 of the First-tier Tribunal's decision. And at least on one reading, I appreciate that my Lord Justice Lewison may have read it differently to the way in which I advanced it, but in my submission that's at least capable of being read, as it appears the Upper Tribunal read it, which is that for the purposes of direct attribution, the first-tier tribunal regarded medical condition and understanding as conceptually distinct things.
Well, you've got to read the decision fairly and as a whole, and the headline take-home point on this is paragraph 11, which says that the cause of the change of understanding was the therapy,
Yes.
or the treatment rather than the index offence.
Yes. And if they'd then gone on to say, let us assume that change of understanding constitutes a change of medical condition, nevertheless, that change of understanding was based on treatment, and a change based on treatment is attributable to treatment and not directly attributable to the original injury. If they'd said that, well then, I might have raised an issue as to the rationality of that conclusion, for reasons I'm going to come to in a moment. It would be inconsistent with Williams and inconsistent with one of the other cases in the bundle. But that's not what they're saying in paragraph 50. They're drawing a distinction between medical condition and change in understanding. And that's the way the Upper Tribunal understood it in my submission at paragraph 6. And the submission I'm making now is that regardless of the way in which this court instinctively reads paragraph 50, that approach was reasonably open to the Upper Tribunal, exercising its section 15 function.
But don't you have, as my lord says, you have to read the decision fairly and as a whole. And this whole section has been introduced by what they say at paragraph 45. If we are wrong about there being no material change in his medical condition.
I accept that.
So the specific question they're addressing in this section is whether any material change is directly attributable to the childhood sexual abuse. And
I agree that's what they're attempting to do, but then when one gets to the crux of it at paragraph 50, that's not what they're doing in my submission.
I understand the submission. I would only observe also that they actually give an additional reason in the second half of paragraph 50, which we haven't so far, I think, heard submissions about. But the point they're making there is placing the emphasis on the word direct as opposed to indirect.
Yes.
Is there any answer to that?
Well, can I deal with the concept of directness in a moment?
Yes, of
course. The submission I'm making at the moment, what's my second submission, is that it was for the Upper Tribunal to reach a conclusion on highly likely. It reached that conclusion in effect at paragraph 6, and in my submission, its conclusion on highly likely, giving the Upper Tribunal appropriate leeway, was one that was reasonably open to it.
Right, well, we've got that.
If the Upper Tribunal had reached a different conclusion on highly likely, then it would have had to have considered whether there were exceptional reasons for the nevertheless granting relief. Perhaps for the purposes of giving guidance to the First-tier Tribunal. Might be the kind of case where the Appellate Tribunal will conclude this is an appropriate case for a declaration, for example.
I don't follow that. If let us suppose that the Upper Tribunal got the interpretation of the phrase correct, but on the question of direct attributability, the FTT's decision stood. There'd be nothing to prevent the FTT from giving guidance to the Upper Tribunal giving guidance to the FTT in expounding the law, but saying that on the facts of this case, the decision was highly likely to have been the same.
I accept that, my lord. It might have concluded, well, it's best just to have a fresh start in the First-tier Tribunal. It's all a bit messy. We're going to send it back. Or it might have concluded that those findings that my lord just described would be bolstered and made clearer for the first tier in the form of a declaration. I'm just making the point that there is a residual discretion under 31(2)(b). So then my third point on direct attributability is to say that, with respect, at the very least, that issue isn't nearly so clear-cut as I understood my Lord Justice Singh to suggest in argument yesterday. And on this, could I ask the court please to turn up the case of Williams, which is in the first volume of authorities at tab 12. And within that, page 309. And at paragraph 29, Lord Justice Ward says that Mr. Crowe, for the authority, submits that the words directly attributable are correctly to be understood to have the adjective qualify the attributability, but directly attributable is the antithesis of indirectly attributable. It seems to me that Mr. Kent is correct in saying that properly construed, and so this is the conclusion of law, what is required is an unbroken line of causation, unbroken that by some new and intervening or supervening event, which of itself is so powerful or dominant as to render the initial operating cause to be wholly nugatory. But of course, it must be a matter of fact and degree in every case. So that's the approach. And then could I please ask the court to read paragraph 30 through to the end of 34.
Yeah.
So those are simply one factual illustration applying the proposition at paragraph 29.
There's also what the passage of Lord Justice Laws.
40.
39 and 14.
Yes. I read that as being consistent with what Lord Justice Ward said. And indeed, Lord Justice Law says he agrees with Lord Justice Ward's reasoning. So just looking at the factual illustrations that we've got, which in my submission elucidate the point of principle of paragraph 29. If one has a back injury sustained through an assault, then an exacerbation when undertaking a self-defence course, and then an exacerbation from lifting a box from the back of a police van, and as a result, one ends up with much more serious disablement than as a result of the original assault. in those circumstances, the self-defence injury and the lifting box injury aren't treated, at least on the facts of that case, as supervening causes, so as to break the direct line of causation. It follows in my submission that a change in medical condition which directly results from treatment will be directly attributable to the injury if the treatment is the direct and unbroken consequence of the crime of violence. So to give a factual illustration of that proposition, if an individual suffers a dislocated jaw from an assault and 2 years after the injury has surgery to treat the jaw and suffers a brain injury through a reaction to the anaesthetic, that brain injury is capable of being directly attributable to the assault. And one sees that in the case that my learned friend touched on, which is in Authority Volume 2, tab 37.
So which tab was
Tab 37 in Volume 2. So this was effectively the case that I've just described. It was a case of reaction to anaesthetic during surgery. The issue in that appeal was whether the treatment, that is the jaw surgery, was in response to the crime of violence or whether it was in response to another jaw injury. That was the issue in that case. But it's significant that it wasn't in dispute and the case was remitted to the First-tier Tribunal for new findings of fact. It wasn't in dispute that if the surgery was treatment for the injury that was caused by the crime of violence, then the side effects of the surgery were directly attributable to the crime of violence.
what room does that leave for the word indirect?
Indirect would be limited to the circumstances described by Lord Justice Ward in my submission, where there is a supervening cause of such power that it renders the causative effect of the crime of violence nugatory. So the submission I make in light of all of that is simply that it was open to the Upper Tribunal to conclude that there was something worth looking at on remission to the First-tier Tribunal.
Yeah.
Don't put it higher than that. My fourth and final point then is I've already made the submission that this court doesn't possess an originating Section 15 power. Rather, it has the jurisdiction to allow an appeal against the Upper Tribunal's decision on the grounds of an error of law by the Upper Tribunal. Now, I accept that this court has the jurisdiction to allow an appeal on a ground that hasn't been raised by the appellant. But I respectfully submit that this court should exercise restraint before exercising that power. And on that point, could I please invite the court's attention to the third of the documents that I handed up, which is the case of Gover against Property Care. This was a case in which a point hadn't been raised before the EAT, before the appeal tribunal, hadn't been pleaded in the grounds of appeal, but then was sought to be raised on the day of the appeal hearing in this court. And could I ask the court please to look at paragraph 10 and 2 lines above letter B, Lord Justice Buxton says, it was suggested that failure to take the point before the appeal tribunal was irrelevant because our task was to review the employment tribunal. And then paragraph 10, that, however, isn't this case because the claimants have a preliminary difficulty that whether or not we in principle simply ignore what happened in the appeal tribunal, the jurisdiction of the court is constrained by what's in the grounds of appeal and in the grant of permission. Now, as I say, I don't submit this court can't do it. All I'm submitting is that there should be some restraint.
Well, that's not. I mean, that seems to be saying the jurisdiction of the court is constrained. And that may be right.
But what
in which case, that is saying we can't do it.
But what this court could do would be to grant late permission to amend the grounds of appeal. We go through some abridged process for that amendment of the grounds. This court then grants permission to appeal on the amended grounds and then allows the appeal on that amended grounds. In my submission, that probably would give the court jurisdiction. And I just wanted to make the submission that this situation isn't analogous to the issue in ground 1 of the appeal, because the construction of paragraph 115 was at least an issue before the Upper Tribunal. And moreover, the proper construction of paragraph 115 is a legal question of wider public importance on which it was appropriate for the Upper Tribunal to give guidance. By contrast, whether it's highly likely that the First-tier Tribunal would in any event have found against LXR on the question of direct attribution is a case-specific question of fact and degree. As Lord Justice Waugh says, it's a question of fact and degree. It's not, in my submission, an issue of wider importance. Now, the question of the proper scope of direct attributability might be thought to be a question of some importance, but in my submission, this isn't the right forum, isn't the right case in which to be deciding that issue. Inevitably, we haven't been able to address the point as fully as we would have done if it had been pleaded. And I would just observe that, on the other hand, CICA isn't irremediably prejudiced if this court doesn't take up that point, because CICA can still run the direct attribution point before the First-tier Tribunal. Sorry to take up the time. That's what I wanted to say on direct attributability. That leaves me with the respondent's notice. We only get there if the appellant succeeds on the appellant's notice. On the respondent's notice, I propose to focus on indirect discrimination rather than on the Flemenos formulation of the Article 14 claim. So I don't ask the court to consider the Flemenos formulation. The indirect discrimination formulation raises, in my submission, two key questions. First, does limiting medical condition of the applicant to symptoms disproportionately adversely affect those with mental injuries compared to those with physical injuries? So is there an indirectly discriminatory effect? The second key question is, if so, is that impact proportionately justified?
So sorry to interject. This is getting straight into Article 14.
Yes.
Can you just help us with which other convention right you say this falls within the ambit of?
Yes. I was going to come on immediately now to say that there are two threshold requirements to be satisfied, but that, as I understand it, neither of those is in dispute. But to answer my Lord's question, the first threshold requirement is that the treatment comes within the ambit of another convention right. And as I say, I understand it to be common ground that the case comes within the ambit of A1P1.
I see.
Because it determines eligibility for a pecuniary benefit, And it also comes within the ambit of Article 8 because criminal injuries compensation is one of the modalities, to use the Strasbourg expression, by which the state promotes right to respect for private life. Now, that's all debated in the case of A against CICA, which the court's got at tab 50. I wasn't proposing to take up time looking at that because I don't understand it to be in dispute.
I only ask because the FTT judgment in our case made some oblique reference to Article 8. I may be wrong, but I don't recall them referring to A1P1. They made the point that Article 14 is not freestanding and proceeded to deal with Article 14. I just wanted to clear away the thickets and see where we actually have to focus.
Yes, I'd have to double check, I'm afraid, but as I recall, we ran both A1P1 and Article 8 in the Upper Tribunal, and there was...
Can I assist? Just in terms of A1P1, the position both before the First-tier Tribunal and the Upper Tribunal that we accepted, the tribunals were bound by JT, which finds that A1P1, a claim for criminal injuries compensation falls within the ambit of A1P1. So that wasn't in dispute and isn't in dispute here. I think Article 8 was in dispute, but because the Article 1 Protocol 1 point ambit had been conceded, it wasn't an issue.
Well, I'm content to limit my case to A1P1 because I'm not sure anything particularly turns.
Yeah, your point, you get through the gate, you're in Article 14.
Exactly. So then the second threshold requirement is that the impact relates to a relevant status.
Yeah.
Here, as I understand it, it's not in dispute that having a mental injury as opposed to a physical injury is an other status for the purposes of Article 14. It's an identifiable personal characteristic, as I think the test was put in clipped. So, if I could then please return to the first key question as I've framed it. Does the narrower approach to medical condition of the applicant have an indirectly discriminatory impact on those with mental injuries?
Is that a question of fact?
It's a question of evaluation based on the evidence.
And who makes that evaluation?
The Judicial Review Court.
So the FTT?
No, the Upper Tribunal.
What is to embark on its own fact-finding exercise?
Yes, for the purposes of convention rights. It's not bound in any way by what the original decision maker thought. That's the misbehaving case. It doesn't matter whether the...
Well, it's certainly true of proportionality, but underlying facts, that's also
What?
an open-ended factual inquiry?
Well, if the original body has made findings of facts, then one would expect the Judicial Review Court to treat those as facts for the purposes of the assessment of the convention rights. But insofar as the question of indirectly discriminatory impact turns on questions of fact, those weren't addressed, those weren't determined by the First-tier Tribunal.
I'm having difficulty following this, I'm afraid. The Upper Tribunal simply didn't deal with Article 14.
No, quite.
So,
I was dealing with it as a point of principle
I see.
rather than a question of fact.
given that they didn't deal with it, what on your submission, what should we now do?
Yes. Yes, it's a massive forward because the Upper Tribunal didn't deal with it either. It's for this court to decide whether there's an indirectly discriminatory impact on the material before this court, and then to decide the proportionality question based on the material before this court. Now, I should say that, of course, I'm not seeking to advance material that wasn't before the Upper Tribunal, so there's no difficulty of not having submitted it earlier. Could I please show you the way in which the Supreme Court has summarised indirectly discriminatory impact for the purposes of Article 14? This is the case of SC, which is in Authority Volume 2, tab 49. This was the case about the two-child benefit cap, which affected more women than men, giving rise to indirect discrimination questions. And if we could look, please, at page 1417. could I ask the court please to read paragraph 53?
43.
Sorry, 53.
53. Yeah.
So that encapsulates the question. In my submission, if change in the medical condition of an applicant is limited to symptoms, then that would disproportionately exclude those with mental injury compared to those with physical injury. And that's because for mental injury like PTSD, but not for physical injury, insight matters and is liable to change. And the evidence we rely on is the evidence firstly of Dr. Green that I've already shown the court. Could I please just flag that up again? It's supplementary bundle, page 274.
Just give me the page again.
274.
274.
And it's what Dr. Green says at paragraph 14. And I'd ask the court to consider the whole of paragraph 14, but in particular A through to C, which the court's already read, so I'm not going to ask you to reread it now unless you want to. It's also supported in my submission by a further report from Dr. Law that you haven't yet looked at in any detail, which postdates the decision of the First-tier Tribunal, predates the decision of the Upper Tribunal, and that begins at page 252. But the passage I wanted to refer to particularly is at page 256. And if I could ask the court please to read paragraph 14. So that's the evidence we rely on. There is no countervailing evidence before this court. And we say that it follows that there's more liable to be a change in understanding of mental injuries than physical injuries as a consequence of the nature of the injury and through no fault of the patient. And if change in the medical condition of the applicant excludes changes in understanding or insight, even where, as here, that affects treatment, then that will have a greater adverse impact on those with mental injuries, in my submission. So that's my answer to the first question, key question. Second key question, is that impact proportionately justified? And in my submission, one needs to assess the proportionality of the narrow approach to medical condition in the context of the other limiting factors in paragraph 115 of the scheme. Specifically, the words so material that allowing the original determination to stand would give rise to an injustice. On a narrow reading of the scheme, so the way interpreted by the First-tier Tribunal and in the way advanced by my learned friends, a person whose symptoms have worsened would have their award reopened, providing that it would be unjust not to do so. But a person whose understanding of their mental trauma has been unblocked, leading to a change in treatment, couldn't have their award reopened, even though it would be unjust not to reopen the award. And so, by definition, narrowing the meaning of medical condition will give rise to injustice. Now, in its skeleton argument, CICA identifies, as I see it, two sets of justifications. First, ensuring legal finality and certainty. And second, simplicity and ease of administration of the scheme. In my submission, a narrow reading, the FTT reading, doesn't promote greater finality or certainty, or if it does so weakly. 3 points on that, if I may. First, as we've seen, the reopening power has a limitation period. Paragraph 116 of the scheme provides that the application must be within 2 years of the acceptance of the award, unless the application can be determined without further extensive inquiries. My second point is that providing that the limitation period in paragraph 116 is satisfied, the drafters of the scheme were, in my submission, content to allow awards to be reopened if necessary to avoid injustice. And third, the Upper Tribunal's reading, broader reading, of medical condition doesn't allow an award to be reopened on the grounds of a culpable error by the original doctor. I've already made the submission that that wouldn't be directly attributable to the crime of violence, rather it would be attributable to the doctor's error. That would be a supervening cause.
Why? Why is that more of a supervening cause than treatment?
Well, because it's entirely a sidewind. One doesn't expect doctors to make negligent mistakes, whereas treatment consequent to an injury is an inevitable consequence or a natural consequence of the injury.
You're contrasting the risks which go with anaesthesia.
Yes.
The risks of mistakes being made in providing treatment.
If in the anaesthesia case, the brain injury was the cause of negligence by the surgeon, then that might not be a direct attribution case.
In the previous example you were giving, referable to a reaction to anaesthesia.
Yes.
As opposed to a mistake in its
Exactly. That's the distinction I draw. And so if one takes those points together, the 3 points I've just made, in my submission, the logic of the scheme is that the limitation period and the injustice requirement serve to secure the level of finality and certainty that the drafters of the scheme considered appropriate. And there's no call for narrowing the meaning of medical condition to secure finality or certainty. I then turn to the second set of justifications, simplicity and ease of administration. Now, I made the submission yesterday on how we say, in summary, paragraph 115 should be applied. If the limitation requirements of paragraph 116 have been satisfied, then the caseworker should ask two questions. Question one, would the current medical condition of the applicant have resulted in a higher award than was originally made if it had been apparent at that time? Second question, if yes, is there any reason not to reopen the award? For example, on the grounds that the applicant or his advisors or doctors were responsible for that not being apparent at the time of the original award. If no, then it's liable to be unjust not to reopen the decision and make the higher award. And on that approach, paragraph 115 is simple and easy to operate. In my submission, a symptoms-based approach to medical condition, the FTT and CICA's approach, wouldn't make paragraph 115 significantly easier to operate. So that really is our case on Article 14. Could I, if I may, just say something very briefly about the appropriate degree of scrutiny? I anticipate that the precise calibration of this court's level of scrutiny isn't going to be decisive for the purposes of the Article 14 question, but could I say something briefly? In SC, the Supreme Court explained that the appropriate degree of scrutiny will vary from case to case, and that different factors may pull in different directions. And there are two factors that I accept, in this case, pull towards a lighter touch approach. First, that the Criminal Injuries Compensation Scheme operates in the field of social welfare. And second, that the scheme has been approved by Parliament. But there is in my submission one factor that pulls in the other direction in this case, which is that in my submission, mental illness is a suspect ground, which, were other things equal, would call for a higher level of scrutiny. And just on that point, could I ask the court to look at another passage of SC? This is back in volume 2 of the authorities, tab 49. At page 1447. If I could ask the court please to read paragraph 158.
Does this case tell us that mental illness is a suspect ground?
I'm going to show you what I say does indicate that in a moment. So I just wanted to have a bit of a run-up, which is to show the court that at letter B on page 1448, the Supreme Court cross-refers to paragraphs 101 to 113 on the issue of suspect grounds. But I just wanted to show you how the suspect grounds fit into the broader analysis, which is 158. So if we could turn back to that, please, it's page 1433. And could I ask the court, please, to read paragraphs 112 and 113?
So the submission is that although mental illness is not specifically mentioned in Article 14, the Strasbourg jurisprudence has, in practice, treated it as if it had been, and therefore is a suspect ground.
In my submission, it falls within the class of statuses that constitute suspect grounds for a different for discrimination.
Yeah.
Yes, if I may just add, there are 2 points here. One, it has to be a status to fall within the scope of Article 14 at all.
Yes.
That is common ground, I think. But even if it is a status, not all statuses are of equal suspiciousness, if I can use that phrase. Race and sex, for example, particularly, well, colour, is pretty much unjustifiable.
Immutable characteristics.
Nationality can sometimes require very weighty reasons, but you're making the submission that mental illness should also be treated as not just a status, but as being a suspect status.
That's my submission. The submission is that a mental illness like chronic PTSD is a disability, certainly in this case, that has historically led to social exclusion and stereotyping. And that, in my submission, is why the Strasbourg Court has said that treating someone differently based on mental faculties is a suspect ground for a difference in treatment. Now, as I've submitted already, I doubt that the precise calibration of the degree of scrutiny is going to be decisive in this case. But weighing up the competing factors, which, as I say, pull in opposite directions, we say that this case falls at least somewhere in the middle of the spectrum in relation to scrutiny. But my core submission, court has my core submissions that however one precisely calibrates the level of scrutiny, this is clearly not, in my submission, a indirectly discriminatory impact that is proportionately justified for the reasons I've submitted. I'm sorry to take so much time. Those are my submissions on Article 14, unless the court has any questions.
The upshot of this submission is that the statute should be read out, just so there's no doubt about the way you
Not the statute, the scheme.
the scheme, right?
Yes. It should be read in the way that the Upper Tribunal read it.
That's what I thought you were going to say. Just,
Yes. So it should be read in a broad and flexible way. Well, medical condition should be read in a broad.
yes. What, paragraph 29, paragraph 33?
One doesn't need to try and, in my submission, it's inappropriate to try and apply any gloss one just treats the scheme as it is. One can proceed on a cautious case-by-case approach to interpreting it. All one needs to say in this case, as the Upper Tribunal did, is that the change in understanding of this applicant was capable of falling within the concept of change in the
You're not going further than that?
I'm not going further than that.
Okay, thank you.
Yes, thank you. Mr. Marathi.
Thank you, my lord. My intention is to be about an hour, and then Mr. Butler will have 20 minutes, 15 minutes to finish off. Mr. Butler stood up yesterday in responding to the appeal and dropped the case on reasonable ascertainability. That is the case that was pursued in the claim form that was before the Upper Tribunal and has been pursued to date. There has been an issue over an application to amend. It's worth looking at the claimant's application to amend his claim form at C98. Because what is notable about the way the claimant is saying that he wishes to put his case now, by way of that amendment in preparing for this appeal, is that he was seeking to argue a broader interpretation which includes capable of referring to etiology, diagnosis, symptoms, disablement, treatment and or medication, and or the original argument of reasonable ascertainability. Not even within that is there the argument change in medical condition includes a person's subjective understanding of medical condition. So now, upon Mr. Butler rising, the whole case comes down to one issue, which is a person's understanding part of a medical condition such that there can be a material change in the medical condition if there is a material change in a person's understanding. Now, that is the case now being advanced by Mr. Butler. It was not the case advanced below. What is being said now, and this court is being asked to find, is that where there is no change in symptoms, no material change in symptoms whatsoever, but merely a person's subjective understanding of the cause of those symptoms, that is a material change in their mental condition. Now, that was not an argument that occurred to the claimant and his representatives at the Upper Tribunal. And one can see that in the supplement, in the submissions that were made before the Upper Tribunal. If one turns to page S302, it could not be more squarely put at S302. So this is the argument for the Upper Tribunal. Mr. Butler at 302, line 13. Now, I endeavour to show you in the decision under challenge if the tribunal didn't determine either of those factual questions, i.e. the case that they were put in, whether there was a material change in reasonable ascertainable medical condition, or whether that material change in what was reasonably ascertainable was directly caused by a child abuse. And they didn't answer that question. But what they did answer, as was accepted in this first instance hearing before the Upper Tribunal in the claim, it answered the questions of whether there was a change in the objective medical condition. So the case very clearly being put by the claimant himself, his own representatives, was the tribunal did answer the question that they were required to ask. And we know there is no challenge to the finding of that they found that there wasn't a material change in the objective medical condition. And again, just to make that absolutely clear, at S288, at the top page, line 5 to 8, I would just like to clarify or emphasise one point. I don't advance a subjective test that there has been a change in what the victim or the doctor thought. So again, now, that is the case they put, that is the case they argued. Courts obviously the court has to consider what the scheme how it should be interpreted to the ordinary person. And if it didn't even occur to the claimant at that stage to make that argument on the fact of his case, then it certainly can't be said, we say, to be what would be an appropriate
So
interpretation.
what are you saying? You're saying we should decide that question adversely to LXR, or that we shouldn't decide it at all because it's never been advanced in the lower courts, lower tribunals?
You should certainly just decide it adversely to LXR, because it demonstrates actually what if, as I say, the ordinary person's understanding, if even their representatives who are very highly skilled, that doesn't occur to them then. My ground one, obviously, is that was a matter that shouldn't have been determined against us by the Upper Tribunal. In terms here, well, as I say, they're putting their case as they are now. This court has to determine what the actual scheme means, and we say, by way of the case, the way they're putting the case now, and it has changed so much, one simply can't accept that is what the scheme must mean. I've got more to say on this.
Yeah.
Now, that is the way the case was put in the Upper Tribunal, and ultimately we're looking at the First-tier Tribunal decision. Now, what was argued by Mr. Butler when he stood up and made submissions took you to the DSM-5. That was not before the First-tier Tribunal.
Sorry, to us to
DSM-5B,
yes, beg your pardon.
and said, by looking at that condition, one can see that regardless of symptoms, the cause of PTSD is intrinsic in the medical condition, and that is the submission that was made. Now, those guidance wasn't before the First-tier Tribunal. That wasn't a submission made on those guidance. What the actual submission made before the First-tier Tribunal, as understood by the First-tier Tribunal, is made very clear in the First-tier Tribunal's judgment, which is at C253. At paragraph 14.
Yeah.
Where the First-tier Tribunal sets out the case that they are responding to. In summary, the case is there's been a serious material change in medical condition since he accepted the original award. This is because there has been a change in his understanding of the cause of his mental health difficulties, and this in turn has led to an increase in his symptomology and a significant deterioration in his mental health. So the record of the tribunal as to how the case was being put to them was that there has been a change in condition because of not merely a change in understanding, but also that in turn has led to an increase in symptomology and a significant deterioration in his mental health.
Would you say that they were accurately recorded what we can see in the skeleton argument for the claimant before them? It really worth just reminding ourselves, because you were showing some passages yesterday.
30303, I think, C303.
Well, I've looked at the whole of that section again. It starts at 302, paragraph 31. It goes all the way through to 304.
Yes.
And paragraph 37 may be of some interest.
Yeah.
The way it's expressed there.
It is all wrapped up together. That is the way the case is put. If you look at 32, paragraph 32, in the appellant's submission, there has been a material change in his condition since the change occurred in 3 ways. 1, diagnosis. 2, the appellant's own clinically significant understanding. So what is required is a clinical significance, and that is explained in paragraph 35, which under the headline, the appellant's own clinical significant understanding of his own condition. And then line 4, this in itself is a significant change in the appellant's condition because of its symptomatic consequences. Now that couldn't be more clearly put. What is being said is the reason the understanding is clinically significant is because of the change in circumstances, and that's exactly what Dr. Law says.
You're right, of course, but the danger is that then each side may be guilty of the same thing, which is taking 1 or 2 sentences in isolation. So, for example, Mr. Butler reminded of what's said in the final 4 lines of paragraph 35, where indeed, for good measure, the words of itself are underlined. So he submits that that was clearly being put before the FTT, that simply a change in such understanding is of itself part of one's medical condition. That's why I drew attention to paragraph 37, that one doesn't read, presumably one doesn't read these documents with a close textual analysis, that one tries to ascertain what was in substance, what was ground 1. What was and as I understand it, ground 1 is summarised in the way that it is at paragraph 37. That you take all the points together.
Yeah, absolutely. So it's beautiful. It's not now. There may be no change whatsoever in symptoms, but actually you just look at understanding. And our case is understanding with no change in symptoms can amount to a change in the medical condition, because that is not the way it was put. And certainly, the important thing is that's not the way the tribunal understood it was being put. And the even more important thing, and this does go to what this court can now decide and what the upper tribunal could decide, is that it was not said it was not said in appeal. The applicant could have judicially reviewed this decision to say, you've misunderstood our argument. Our argument is, as put by Mr. Butler this morning, that understanding of itself, understanding simpliciter, without any change in symptoms whatsoever, can of itself be a change in medical condition. And that's how it should have been dealt with. The way a judicial review challenging the decision should have been dealt with should have been, well, that's our argument. The tribunal misunderstood our argument. The tribunal misrecorded our argument, and the tribunal is wrong to hold otherwise.
It's clear that that's not how the argument was put to the upper tribunal.
Absolutely.
On judicial review of the FTT. One understands that. In fact, it goes further than that. The argument of interpretation that was actually advanced before the upper tribunal was rejected. And that we see that at paragraph 32 of judgment of the upper tribunal. But things have moved on. What Mr. Butler is fundamentally submitting now is that the upper tribunal gave a direction of law. It interpreted paragraph 115 as it did. See in particular the final 4 lines of paragraph 33 of its judgment. And he submits to us that that is correct as a matter of law. So on your submission, what are we now supposed to do in the Court of Appeal? Do we close our eyes to the fact that that's the way it's now being put to us? So that's the interpretation which should be given because of the procedural history. Or do you accept that we should decide that point?
Well, I say it's not a point now open to be advanced, but in alternative, I am going to address briefly the submissions made yesterday in terms of why a change in symptoms cannot be a change in understanding. Well, 2 points. A change in understanding cannot be a change in medical condition without any change in symptoms and diagnosis. And B, even if it could, on the facts of this case, there couldn't have been, there simply wasn't. And just to be clear, so for example, when Mr. Butler is advancing his case now, he says, and it's put that his argument on his interpretation, the first question is, would the current medical condition have resulted in a higher award if it had been apparent at the time? We're talking about August 2019. The short answer is it was apparent at the time. On the medical evidence that was before the First-tier Tribunal, on the report of Dr. Pereira, it was apparent at the time, because that's what she says. She diagnoses PTSD. She diagnoses PTSD as a result of the child sexual abuse. There is nothing, and Mr. Butler made submissions to suggest something had changed between August and November 2019 yesterday. That's simply wrong. The evidence was nothing had changed between those dates, and therefore it was apparent at the time on the basis of the evidence of Dr. Pereira. And so I'll just take you through that, if I may. What I'll first do is take you through Dr. Lawes' evidence. Dr. Lawes' evidence is at 205. Now, obviously, we're in this S205. We're in this slightly odd situation where we're now addressing arguments that weren't raised below. So if one looks at S205, which is at tab it's at tab 28 of the bundle. So this is the letter that was before the First-tier Tribunal, and she sets out at the top of paragraph page 205, for the reasons I give below, I'm of the view that the current presentation amounts to material change in his condition. And so she then sets out the change in symptomology and presentation that the tribunal rejected. Now, this letter could be clearer. We say it's sufficiently clear in it that it's not saying of itself an understanding changes the medical condition.
I'm not even sure it says what the UT thought it said. What the UT said is, if I've understood Dr. Lawes' evidence correctly, it says LXR's understanding of his must be symptoms and their causes was, quote, fundamental to the nature and treatment of his condition. But I'm not sure this letter actually says that anywhere.
No. But we certainly know what Dr. Law's view is. And the other point is, remember, there is a medical expert on the panel who makes their own decision if it's a medical question. So it'd be for that expert to make a decision and leave the First-tier Tribunal, not a Upper Tribunal judge without that expertise. But at 252, Dr. Law could not be clearer. She has asked the question.
This is post FTT.
Yes, it's post FTT, but we're looking at post. We're being asked by Mr. Butler to look at various matters like the DSM-5 that wasn't produced before the First-tier Tribunal.
Including this letter.
Yes.
Yeah, so it's question 1.
Question 1. Why do you consider that the change in his understanding of the cause of his symptoms is a change in his medical condition? The change in his understanding of the cause of his symptoms is a change in his medical condition due to the fact that this change in understanding led to a change in symptomology and presentation, which is what constitutes a medical condition. So that's directly contrary to the case that put to you yesterday. Now, to make that clear, she repeats this 3 different times when asked questions in a slightly different way. For some medical conditions, including X's, this is number 2, do you consider that it is clinically significant for a person to change their understanding of their condition? If so, why? I consider that it is clinically significant for a person to change their understanding of their condition if the change in understanding leads to a change in symptomology and presentation, which in this case it did. And just to underline the matter even more, when she's asked question 10, at the bottom of 254, if you consider that it is clinically significant for a person to change their understanding of their condition, see question 2, What is the cause of that change in his understanding? She then repeats, I consider that it is clinically significant for a person's understanding of their condition to change if it leads to their change in presentation and symptomology. So that could not be clearer, that on the doctor's view, the doctor they were relying on, Dr. Law, there is only a clinically significant change in a person's condition if there is a change in symptomology and presentation, and one's mere understanding alone without it is not sufficient. Now, just in terms of then Dr. Scott Pereira's evidence, at the top of page 254, it's worth noting that paragraph 3, Dr. Law's evidence is
254.
sorry, 253, sorry, I apologize.
253. Yeah.
The change began in his understanding, began to occur from the beginning of 2020, see that at the end of question 3. So that's after the Dr. Pereira Scott report. If one goes back to Dr. Laws's another letter that we haven't looked at yet, but if it's at number, just for reference, is at S112. So this is a month before the Dr. Pereira Scott report. S119, sorry, I apologize. 119, sorry. So this is a month before the interview that led to the Dr. Pereira Scott report, so that's in November. The symptoms are, they don't expressly refer to the MOD case, but they're expressly referring to the court case that they continue to have against the MOD. He talks about living with frustration on a daily basis due to him trying to fight a court case. That's obviously not the one relating to child sexual abuse by this stage. And he talks about often, bottom of 119, his thoughts often make associations towards the person, the place, and subsequent fallout of the traumatic episode. Now, so her evidence is that the change in understanding doesn't occur until 2020. We then have Dr. Pereira Scott's report. And if one turns to page 322, sorry, it's 167. It's
167.
167. Bottom of 167 at 322 and 323, she does criticise Dr. Yankov's approach. It says, maybe hadn't seen some of the earlier background history, not reviewed the medical history. Over the page at 168, paragraph 324, she identifies the PTSD that was before the index incident, and then indeed sets out the criteria for the diagnosis of the post-traumatic stress disorder at F43.2. And at the top of page, one can see this sort of most clearly at page 171, the top of 171. We can see, well, sorry, I'll go back a little first. 170 under causality. In relation to causality of his psychiatric symptoms of primary trauma, this is a 340 court, contributing to the symptoms of post-traumatic stress disorder was a childhood sexual abuse. So that's her finding of causality. She finds he's got PTSD. That is notwithstanding, at page 171, paragraph 345, we see at that stage, he remained solely focused on maintaining his anger towards the padre and the forces. He remains solely focused on this and dismisses any other possible explanations for his psychiatric presentation. So her evidence is very clear. When she sees the claimant, he remains solely focused on the padre incident. he dismisses any other explanations for it, so he certainly can't be said to have the understanding. Yet she still diagnoses PTSD caused by the child's sexual abuse. So to go through the diagnostic criteria and the symptoms yesterday and say, well, look, this all shows that the cause of the condition is intrinsically linked to the condition itself is clearly wrong, because on Dr. Pereira-Scott's own view, she diagnosed that PTSD, notwithstanding his clear refusal to accept any other explanation for that psychiatric presentation.
And the date of this is December 2019.
The report is December 19. The consultation itself was November 19.
I see. Right. And was this before the FTT?
Yes, this was before the FTT. So, actually, a claimant's understanding, if one is saying, well, a claimant's understanding is fundamental to PTSD, it can't be the case, because Dr. Pereira-Scott identified the claimant as having PTSD caused by the child sexual abuse. And she did that at a time 3/4 months after he had accepted the award, and at a time where the evidence was clear there was no change in his understanding of the condition as he was expressing it. Now, so when it's put to you now that the way to approach this is if the current condition would have resulted in a higher award if it had been apparent at the time, the fact is it was apparent at the time. It is simply a case of different doctors coming to different views as to causation. And you know, if Dr. Pereira-Scott isn't herself isn't as clear as that, we can see.
So why do you say different doctors on change different views about causation? She's actually saying causation is the child sexual abuse,
Yes.
even though he denies it, and it appears the psychiatric symptoms arising from the abuse have been transferred.
Sorry, the case is about different doctors have come to different conclusions as to causation, because the different doctor is the Yankhoff
Oh, I see.
doctor,
Right, yeah.
upon whom the previous decision is based.
Yes, I see.
And I say it's an exercise of a judgment by it was CICA in this case, could have been the First-tier Tribunal. They'd have looked at the Yankhoff report and come to that conclusion. They make a conclusion on the basis of that evidence. What cannot be allowed to happen is that the scheme can be reopened where there is a simple change in causation between two different doctors.
Looking at the FTT's decision, paragraph 49, 259, they say in the application for review the following is stated: it is because of that report, i.e. Dr. Pereira-Scott's report, and other developments, including subsequent work, his condition has changed materially both in terms of his own understanding and also in terms of his psychological presentation and symptoms. But according to Dr. Pereira-Scott, he didn't understand, and at that time.
Well, the way it was put in the initial application for a review, the initial application to reopen, was that his understanding had changed in light of the First-tier Tribunal's decision, which refused compensation in the Padre matter, and the report that he had procured around 14 months previously. It is later put that it is the Pereira report and the work done subsequently. So, as I say, the answer, this case boils down to simply a disagreement over causation. And it just in terms of whether this was apparent at the time or not, I refer to Dr. Pereira-Scott, but one can see, just as an example, Dr. Galloway back in 2007, section 4, sorry, it's page page 47 of the supplementary bundle. And the relevant part is opinion under paragraph 49.
So page 47.
Sorry, it begins at page 47 and the relevant part is page 49.
Page
Under
49, right. Which bit of page 49?
under opinion, the one paragraph
Yes,
there.
that
Please
part.
read that.
Yeah.
So what is now being put is you look at the DSM-5 guidance, and actually there's a lot of reference to symptomology. Because there's reference to, within that symptomology, to PTSD being caused by something specific, then the something specific that it is caused by is intrinsic in the medical condition itself. So if you don't understand that, then it's intrinsic in the medical condition. But that is simply wrong and cannot be the case, given Dr. Pereira's assessment of him having PTSD caused by the child sexual abuse, without the understanding of that that was the reason. And you know, when one just steps back and says, here we have the same diagnosis, PTSD, we have the cause that is identified by Dr. Pereira-Scott and others like Dr. Galloway before, there is no material change in symptoms. Williams requires a pure comparison, paragraph 26, between the medical condition at the time and the medical condition as it is now known. And the reality is, you know, whether you're dealing with symptoms or a wider medical condition, PTSD, where the symptoms are the same, the diagnosis is the same, it cannot reasonably and ordinarily be understood to an ordinary person that there is actually a material change in your medical condition. And I say that if that were the argument that was to be pursued, should have been in the judicial review claim form, it wasn't. If that had been pursued, then if we were just looking at that narrow issue, then the question of direct attributability would have arisen, because the claimant's argument on the judicial review would have been, one, the First-tier Tribunal erred in misunderstanding our case and erred in finding that the change in symptoms and diagnosis alone can't be a material change in medical condition. They would then also have to have gone on to challenge the direct attributability finding. The case that you've been referred to talks about it being a question of fact and degree. It was a question of fact and degree that the tribunal looked at, and they took.
What are we to do with that issue? It's not part of your grants of opinion.
No, but that's. I will come on to the way it developed, but the point is that all of this stems from the fact that the case was not put in a very different way in the claim form to that which was put before the Upper Tribunal, and that's a real difficulty here. But if one is going back to actually what parts of the findings of fact did the First-tier Tribunal make an error of law, we say no, and so it couldn't have been overturned. If it did make an error of law, so it could have been overturned, then there is still that direct attributability finding of fact and degree, and that wasn't challenged. Now, had the claimants put their case in the way they're now putting it, to say the tribunal got it wrong and understanding of the cause itself can amount to a change in medical condition, then they would have had to have attacked in their judicial review the direct attributability finding, but they didn't, and that's the reason where we are. We say it is open. You know, if this court thinks that there was an error of law in the First-tier Tribunal's decision, including within understanding. So the error of law would be that the First-tier Tribunal failed to consider whether understanding alone amounted to changing medical condition, or failed to erred in finding that change in symptomology and the diagnosis couldn't itself amount to change in medical condition, but that change of understanding could. If you think that the First-tier Tribunal erred in that respect, then the findings of fact remain. And we say the materiality point must be right, because if it goes back to the same tribunal and that's the only error they made, then necessarily, it doesn't have to go back to the same tribunal, necessarily there is no material error, because the outcome is absolutely the same. Now, in terms of why that is not before, why any argument is not expressly before the court.
Sorry to press you on this, but it may matter. You've made your submission very clearly in terms of absence of materiality, and I understand that submission. You haven't expressed it in terms of section 31, so can I take it that you're not relying on section 31 for this court?
If the error is limited to the question of understanding, whether understanding can be part of a material change in medical condition, then I would certainly say this is certainly a case in which the outcome would have been the same, because the tribunal expressly say that. And there was no, it's a question of fact and degree, as William says, and that wasn't challenged at the time. Do I need to say, well, ask the court to make its own decision? Would the outcome be highly likely to have been the same? Well, I say I don't need to, but I can do. That certainly, in my submission, would be the case, because if one has to, if a change in understanding is sufficient on its own with nothing else to amount to a change in medical condition, one would have to consider whether that change in understanding itself is directly attributable to the original offence and the original assault. And in my submission, it can't be when it happens, as the tribunal found some 40 years later after treatment, when, as particularly we know, the other course, the recourse that the claimant had to compensation, which was his claim against the MOD, both his civil claim and his CICA claim, had failed. That cannot be direct attributability, and you'd have to look at direct attributability in the sense of what is the cause of the change of the understanding, because that is how we are limited to the change here. Just in terms of how it did, how it was put. Now, before the Upper Tribunal, at S335, so it must be C335. Sorry, I apologise. Yeah, sorry. C21215. Sorry.
We're doing supplementary 321.
Sorry, I apologise. I have the wrong reference. Sorry, it's a core bundle 215. Sorry. So this is the response to the judicial review as it was put at paragraph 65, where we raised both materiality in the strict sense, and although I don't especially refer to section 31A, outcome was highly likely to have been the same.
Well, that's the substance of section 31 to
Yes, absolutely. And you know, the basis for that can be seen quite clearly in the argument at
yeah, there are bits in the transcript that refer to section 31 to
and our position in terms of our skeleton argument was quite clear that at C178 paragraph 10 at C178 in particular 10.4, even if they were right and the ET had in some way to interpret paragraph 115 of the scheme, the word reasonably ascertainable, a medical condition plainly was reasonably ascertainable as of 2019. There are frequent references throughout medical reports before that time to the CSA. So that's what we were saying. If on the claimant case, the error is that the first-tier tribunal didn't consider whether the condition was reasonably ascertainable at the time of August 2019, well, the answer is plainly it was, and it would have been, because there's lots of reference in the medical record to that, the sublimation or the transfer of anger. And Dr. Pereira comes to that very conclusion just 3 months later when there's been no change. That was what was argued. Now, in terms of then what happens on appeal, I will turn back to Singh under a moment, but just so the court are aware, in the application for permission to appeal to the upper tribunal, the materiality point was a point raised. So if one turns to S331.
Bear in mind that you said you'd give Mr. Butler 20 minutes.
Yes.
S331.
S331. At point 3, ground 3, the argument was that the 335, the upper tribunal, had failed to provide an alternative definition for the ordinary meaning of the words applied by the FTT, and then considering whether the outcome would have been the same or highly likely to have been the same in light of that definition.
I'm so sorry, where are you looking at?
So ground 3 at the bottom of 335.
335, sorry. Yes, thank you.
And that goes through to 8.4. So at 8.4 we say, having found that the FTT erred in applying a dictionary definition for the term medical condition, the UT should have gone on to consider whether the outcome would have been the same, or how you actually define it and whether the outcome would have been the same. Now, we then go back to bundle C, and the upper tribunal said at C 139 in response, sorry, not 139, 146.
Where are we?
Sorry, core bundle 146. Sorry.
So this is the upper tribunal decision refusing permission to appeal. Yeah. And what do you want us to read?
So paragraphs 11 and 12.
Yeah.
Now, so our understanding of the decision goes back to, begins at paragraph 21 of the upper tribunal decision at page 137, where they immediately say the first-tier tribunal went wrong in dealing with dictionary definitions of medical condition, and then from 23 to 31 deal with what medical condition does mean, and then says, I'm not going to myself try and attempt a definition, but it's wider than what the first-tier tribunal thought. And it's within that passage that they refer to the reference to etiology, diagnosis, symptoms, disablement, medication or medication. Now, if it's the case that the first-tier tribunal went fundamentally wrong in failing to assess properly what the changing medical condition was, which is what we understood the upper tribunal was saying, then of course their finding on direct attributability would fall away, because one has to ascertain whether first has to look at the basis on which they made findings of direct attributability, and if, for example, they failed to consider etiology, diagnosis, symptoms, disablement, treatment or medication, etc., then that finding on direct attributability will fall away. But what's now being said is it's not a fundamental flaw in the first-tier tribunal's decision. It is limited to paragraph 33, and the point made in paragraph 33 by my Lord Justice Singh, which is it's limited to the understanding of the condition. Now, if that's the only error in the first-tier tribunal's approach, then the findings on direct attributability must stand. To say that wasn't our understanding of that tribunal decision. That certainly wasn't our understanding of the basis on which the claimants were putting their claim, because they put their claim very differently. So that is where we are, and as I say, my submission is the reason we are where we are comes from a complete failure to complete change of case, and the way the case was put very, very differently that was dropped yesterday. We say because of that, and because of the way the case was put at the first-tier tribunal, as I've shown you, the arguments made yesterday just wouldn't have any weight anyway, and it's not open. It wasn't open for the upper tribunal and wouldn't be open for this court to say the first-tier tribunal erred in respect of those arguments when that wasn't challenged, and the submissions made yesterday don't bear up with the medical evidence in any event. My Lord, I need to deal just very briefly with Jones. It will be very brief, and our position is this. Jones in the Supreme Court, which you referred to yesterday, Lord Carnworth, the principles, technically overstood, but obviously they're principles, which would bear a lot of weight about the importance of the upper tribunal developing structured guidance of expressions for tribunals. We absolutely agree with that in order to reduce the risk of inconsistent application. The difficulty of that in this case is that the tribunal just didn't do that. They said in our submission, well, the first-tier tribunal went wrong, but we're not now going to say what the approach the tribunal should have been. In this case, what the upper tribunal should have said, if we are limited to the question of understanding, is understanding can include the changing medical condition can include a change in understanding on the facts of this particular case, and this is why. Whereas they didn't, and therefore, the short point is that the decision of the upper tribunal is very, very difficult to understand, and it's very difficult for the CICA or first-tier tribunals to follow it in order to apply it to future cases. The other important point about that is, and I would refer the court to the Hutton case, which is at tab 31. And in particular, paragraph 57 and 58.
57.
It's Hutton. It's tab 31.
Yeah, paragraph 57, you said.
Yeah, so the guidance begins at paragraph 52, and the Court of Appeal is drawing together various strands that it includes the Jones guidance from Lord Justice Carnworth. And 57 really sets out the proper approach in terms of the respect that each different level should be affording to the findings below. And
Yeah.
and summarises then at 58, 1 to 3. So, I apologise. So the cardinal point obviously is that the first-tier tribunal that has heard the evidence, seen the evidence, and it is its findings of fact cannot be disturbed. There is a blurring as between what amounts to a question of law and principle, law and fact. Sorry, the blurring is between what amounts to law and fact. If it comes to the upper tribunal giving guidance on particular parts of the scheme, but if one takes an expression and the upper tribunal is entitled to say, well, that's a question of law, which then permits the upper tribunal to intervene, then that's a question of law, and the Court of Appeal can equally make a determination on that question of law. Now, it would make a determination on that question of law, giving due respect to the expertise of the specialist tribunal, but it is still a question of law that the court itself must properly decide, because what can't possibly happen is that questions of law are not open to be challenged on interpretation in the High Court if the upper tribunal goes wrong. So if and insofar as the question of understanding is a question of law, then it is open for this court to correct it, and the court must correct it because it's an error of law. Insofar as one has to give weight to the expertise of the lower tribunals. Well, actually, if the question of medical condition, when one's looking at the question of medical condition, one would have to give as equal weight to a doctor who was on the original first-tier tribunal panel who came to a finding of fact that it wasn't part of medical condition, as one would to a non-qualified doctor who, on the upper tribunal. Then dealing with the human rights point, my submissions on this are fairly detailed, so I'm not going to go through everything. I will ask the court to read through those submissions that begin at paragraph 12 of the supplemental argument. I just want to highlight some points. The first point is that, as I say, at paragraph 12, the applicant's case introduces discrimination and difference of treatment into the scheme. And the important thing to note is it's a difference of treatment as between different disabled people. So at the very beginning of yesterday, I took the court through the various different types of people that might be able to make claims, such as people with epilepsy, people with functional brain disorders, all sorts of people who are disabled. Pretty much anyone who gets an award now, because awards can no longer be given to very minor injuries. Virtually everyone, I think it's safe to say, virtually anyone who gets an award will be classified as disabled. They certainly will have a disablement to some extent. So what is being asked is for, or it was being said, is that Parliament should have introduced discrimination against someone, say, with epilepsy, because someone with epilepsy, even though there might be different difficulties in causation, saying where that epilepsy comes from, which there will be, Parliament should give preferential treatment to those with mental health disorders. And that is quite a very far-reaching submission that is being made. Now, I refer in my submissions to the...
But in effect, I think part of what you're saying is that Mr. Butler can't say that LXR's mental injury is a suspect ground, as he put it, because he wants to distinguish not between disabled on the one hand and able-bodied on the other, but between different types of disability. And he wants discrimination as between those with physical disability and those with mental disability.
And we say that could not possibly be justified, because where do you draw the line? Where do you draw the line between someone with epilepsy? And there is sort of reference, for example, in certainly one of the consultation papers, to particular issues relating to causation arising for someone with epilepsy. I'll take you to that actually now, because it is worth looking at. So the consultation in the 2012 scheme is in the supplemental bundle. It begins, the relevant part begins at S54.
54.
54, S54.
Yeah.
Now, so this is the 2012 consultation. Now, all the authorities that I refer to that deal with the Criminal Injures Compensation Scheme and justification, Article 14 arguments, go back to the 2012 scheme, which is where the current scheme, consultation, which is where the current scheme comes from. Obviously, you don't have the whole consultation, it's a long document, but within, at page 72, sorry, yeah, at 72, the government at the time were consulting on medical reopening. The relevant part to read is medical reopening and deferral.
What's the point you're making?
The point is that this was the medical reopening provisions were considered by government and Parliament at the time in 2012, and in due course I will show that there was specific reference to some specific disabilities. So what then happened, and just for the sake of completeness, if one goes to page 77, and I'll just describe what happened. I don't need to for the court to read it. From paragraph 216 to 218, the government decided they were going to remove medical reopening and replace it with a different system of deferral. But in light of submissions that were made, in light of the consultation, they decided the general view was that that wouldn't be fair. So they kept the rules as they were. And they dealt with equality issues. One can see in the impact assessment, which begins at 255 and the relevant part is at 256. And
So which page?
relevant part is 256.
81.
Sorry, S81. Sorry, it's the 256 of the different numbering. Sorry, I'm confused by the numbering. S81. Sorry, thank you.
So which paragraph?
Paragraph 433 is where they consider disability, and 434. And mitigation and justification.
Yeah.
So this scheme goes through a consultation. Government then put it before Parliament. Parliament agrees it. Both houses agree. Now, there were concerns raised during consultation about people with epilepsy if there was a change. Now, on the claimant's case, people with epilepsy, where there might be equal difficulties with causation, and there'll be difficulties with causation in all sorts of physical and neurological conditions that are not mental health disorders, or on his case, they would be excluded. And that's contrary to what if his case, if there is differential treatment for people with mental health, then why shouldn't there be differential treatment for people with other disabilities? Now, the claimant relies on indirect discrimination, and the case law, one looks at, I'll just refer you to my submissions at paragraph 15 to 16, where I refer to the relevant part of SC. And if one is proceeding with a case of indirect discrimination, one has to show a disproportionately prejudicial effect on a particular group of people. As the Supreme Court noted within SC, as set out by the European Court in D8 and Hugendijk, the starting point for the applicants to submit, it was the starting point to submit evidence, again based on official statistics, giving rise to a prima facie case or presumption of discrimination. And the Supreme Court, paragraph 53, went on to state, it has to be shown by the claimant that a neutrally formulated measure affects a disproportionate number of members of a group of persons sharing a characteristic which is alleged to be the ground of discrimination to give rise to the presumption of indirect discrimination. So there has to be strong evidence through official statistics by reference to the Czech Republic case to show that actually a particular group of people are being disproportionately affected. And there simply isn't that evidence in this case. What is relied upon is a report by Dr. Green, who actually says at 14D, at page S7274, that actually post-traumatic stress disorder is a condition which originates from specifically emotional traumatic experiences, which can usually be identified. So she specifically says actually the causation difficulties that the claimant is relying upon for those with mental health disorders doesn't actually apply so much to PTSD, because usually you can identify a cause, because that's the point of PTSD is it comes from a particular act. So PTSD is really no different from any other assault or event where one is there might be competing causes.
Can I just ask you about paragraph 17 of your skeleton on this point? You
Yes.
say correctly that the burden was on LXR to show that the disproportionate effect. You go on to say the FTT did not err in finding that he failed to discharge that burden. What do you say to Mr. Butler's point that we have to decide that for ourselves?
Well, you would have to decide the proportionality question yourself, the justification question yourself.
But what about the antecedent question before we get to proportionality?
Well, when one is dealing with, this is legislation, this is statutory legislation, a statutory instrument approved by Parliament. When one is dealing with a statutory instrument, there has to be some significant evidence of a disproportionately
That's not my
effect.
question. My question is who decides? Is it a question of fact for the FTT? Or if we are conducting an exercise in reviewing the compliance of the scheme with LXR's human rights, is it for us to make that decision? That's my question.
I think it must be a question of fact for the First-tier Tribunal, because that is where questions of fact are going to be considered. That is where they're on an ordinary dispute of fact. If we're looking at, for example, an employment tribunal, that is where you would have an evidential argument over whether there is a disparate impact or not.
So you say, is this right? Whether LXR had shown that the reopening provisions adversely affected a disproportionate number of people with a particular status, that was a question for the FTT as a question of fact, and that is not to be reopened unless in reaching that conclusion, they have themselves made some error of public law.
I think that is right. I caveat that with the slightly odd thing about this is that although the first-tier tribunal is making a decision based on the argument that's put before it, the claim before the upper tribunal is then obviously a judicial review claim. So there would then be a new opportunity for new factual findings to be made, but that just didn't happen in this particular case. So I don't think I don't need to rely on the factual point, because I mean my submission is quite clear that there just is not, doesn't begin to give rise to a statistical or even evidential anecdotal argument that people with PTSD are put to a substantial adverse effect, disproportionately affected in such a way as would then require there to be discrimination between different disabled people.
Well, it's 1:45 now, so how are we going to use the rest of the time?
I make my submissions on justification. I just want to.
It's 5 minutes past, 20 to 1.
I will be 5 more minutes, my lord. I make my submissions in justification in writing. Can I commend to this court the approach of the Court of Appeal in Sullivan and the Isle of Wight Council, which is at tab 56 of London. I won't take it, the court to it. My Lord Justice Holgate was on that, in that court.
I'm not sure I was actually. Maybe mistaken.
Paragraph 76 onwards, when one is dealing with
Of what, sorry?
Sullivan.
Of?
Sullivan, the case of Sullivan, it's at tab 56, which is in bundle 3.
Oh, that's
so 76. So I commend this as a cogent and very workable approach as to how to deal with questions of legislation here, subordinate legislation, as to whether it is justified. 76, one starts with the aim or purpose of the legislation. And then once one has identified that, paragraph 77, the question essentially is whether the relevant legislative provisions satisfy a proportionality test, taking into account various matters such as those referred in SC as to the respect that must be given to decisions of the government and parliament in fields of social measures such as this, which the authorities is clear that is the case. This is such a field where Parliament has considered the matter, and Parliament doesn't have to consider expressly the particular issue that comes before the court. The question is simply whether Parliament has generally considered the matter, and Parliament clearly generally has considered the question of the reopening provisions, whether that has an impact on disabled people, whether they should remain, whether they should be removed. Of course, they haven't considered this particular case, but Parliament and government can't consider individual cases. And whilst in paragraph 112 of SC, Lord Reid says, puts disability as not a suspect ground in the sense of, very suspect ground, but equally not in the level of being non-suspect ground. I think this particular reference is to I think Lord Reid says that's a relatively sort of an approach somewhere between the two, the suspect and non-suspect approach taken in paragraph 112. That is a matter that you obviously take into account the fact that disability arises, but you'll also take into account the fact that they're asking for discrimination against other disabled people. Putting all the matters together, we say this scheme is very clearly justified. There are a number of purposes of the scheme. One has to look at the scheme and the provision. The purpose of the scheme is to provide compensation as a matter of social solidarity. It is not full compensation for injuries, and that's made clear in the case of ZX I refer to. It is a payment, a sum to reflect social solidarity. Another purpose of these provisions is quite plainly finality and certainty, the requirement that judicial decisions are made on the evidence that is before them, and they should not normally be reopened. And that is a very important principle, as I set out in my skeleton argument, numerous cases talking about that being a very important principle of law. There is then the fact, the context, that this is all within the context of the distribution of limited funds. And so Parliament can't simply be intended to have a scheme whereby any claim is should be allowed. We simply don't know what the extent of the claimant's case would be as in terms of other claims on the fund. But one has to take into account that it is a fund which has limited funds. There is a distribution of limited funds, and it has to be simple and easy to understand. And those are all purposes that are set out in the case of A in CICA, which is at tab 50 of the bundle. The case of Pieris, which is at tab 63 of the bundle, I would particularly refer, Pieris is at 53 of the bundle, from paragraph 48 onwards. My lords will have seen the Supreme Court case of A, which deals with justification in detail and deals with those three approaches. Pieris also deals with that, which is at tab 63.
So did you say 63 or 53?
Sorry, 53, sorry. Apologise. And ZX, which is a High Court decision dealing with very similar argument, also dealing with the scheme.
What's the reference to that?
It's tab 55, which deals with justification from paragraph 158 onwards. So we say simply it doesn't begin to be a situation in which it can be right that the decisions made by parliaments in the past could be held to be disproportionate. My lords, those are my submissions. I apologise for being a bit longer than I said I would be.
Yes, thank you. Yeah. Yes, Mr. Butler.
Thank you, my lord. I will finish on time. Can I deal first with the question of how the case was put before the Upper Tribunal and what significance that has to this appeal? My short answer is it has no impact other than being somewhat embarrassing for me. The question on this appeal is simply, in my submission, whether
wait a minute. You're responding, are you, to you're applying on your cross appeal? What other right of reply do you have?
Well, I don't. I'm sorry. I was trying to use some of my time on this basis. If I'm shut out on that, so be it. On the Article 14 point, then, I have one point.
Yeah.
Which is that the central thrust of my learned friend's answer to this is that I would be creating new discrimination through my Article 14 complaint as between those with mental disability.
Yeah, different categories of disabled people.
Physical disability. Now, that would, in my submission, be a fair answer to my Flemenos formulation of Article 14. But in my submission, it is not an answer to my indirect discrimination formulation. On my approach, my indirect discrimination approach, the test under paragraph 115 falls to be applied in exactly the same way to both physically disabled and mentally disabled people. Just to draw an analogy, in the case of SC, which was about indirect discrimination on the ground of sex in relation to the two-child limit on benefits, the claimants weren't suggesting that if they succeeded, the two-child cap would only be disapplied to women. The consequence of success on the attack to the neutrally formulated measure was that it would have to be amended for everybody. And that, in my submission, is the effect of my indirect discrimination argument. So if I win on Article 14 indirect discrimination, then the neutrally formulated measure, medical condition, will fall to be read in the way identified by the Upper Tribunal for everybody, whether they have PTSD or whether they have epilepsy related to a injury. And that's the only point I wanted to make in reply on Article 14.
Can I just ask you on Article 14, if you can help us on this point of principle? It seems to be common ground before us that if we have to address the question of proportionality, that is a question for this court to assess for itself. But on the logic, the anterior question of whether you have shifted the burden, so they have to justify it as being proportional, on whether there is indirect discrimination in the first place. I think it's put in two different ways for CICA. But one, that was a matter of fact for the FTT, and this court is not entitled simply to form its own assessment on that question. But even if that's wrong, the alternative submission, I think, is made that if this court looks at the evidence for itself, it's abundantly clear that the evidence doesn't get you over the threshold you need to overcome. But can you help us any further on that point of principle? What is the correct approach?
On the point of principle, my submission is, and then I'll look at what assistance one gets from misbehaving. My submission is that on an appeal against the decision of the Upper Tribunal, where the Upper Tribunal has decided the convention point, then this court may be constrained to identifying an error of law in the Upper Tribunal's determination of the convention ground. By contrast, on the claim for judicial review against the First-tier Tribunal's decision in the Upper Tribunal, in my submission, the Upper Tribunal isn't constrained by the First-tier Tribunal's view on the convention issue. And that is because the Human Rights Act charges the court with deciding whether there is a breach of convention rights.
But here, of course, the Upper Tribunal didn't form any view on convention rights. It didn't get that far.
No, which is
So
why...
the only view that we have is that of the FTT. So what, in the light of my Lord's question, is our function?
Well,
On that logically anterior question, is there disproportionate indirect discrimination?
so if one applies the structure that I've just submitted is the right one, applies that to this case, because the Upper Tribunal didn't decide the convention issue, and because I've put it in issue through the respondent's notice, this court is effectively in the shoes of the Upper Tribunal on a convention challenge. And it follows from what I've already submitted that this court then isn't bound in any way by the views that the First-tier Tribunal expressed on the convention issue, because this court stands as the first court for the purposes of the Human Rights Act deciding the convention issue.
I find that difficult to follow. Lots of contexts in which the court sits on judicial review and doesn't assess for itself questions of fact. In fact, that's the primary position. It isn't, for example, if you're reviewing a decision of the Secretary of State.
Yes, on public law grounds, but not in relation to.
In human rights grounds. You don't start on a judicial, just because it's framed as a judicial review case under the human rights law, you don't start making assessments of fact for yourself. There's lots of authority to that effect. Sometimes there's a dispute about whether somebody was in Syria at the time. He's alleged to be a terrorist. It wouldn't be conducive to the interests of national security for that person to be given certain rights. It's absolutely clear that when you have to perform the proportionality exercise, the court has to perform that for itself, and that's been very recently, well, it's been affirmed in a number of cases, but in July this year that was confirmed by the Supreme Court in Schwidler. So you can't ask, for example, is the assessment of the Secretary of State a rational one? That's not the question for the court on a judicial review application under the Human Rights Act. I get that. But the more difficult question, and I'm not sure at the moment at least that we've been shown any authority on this, is what if in arriving at the decision under review by the court, the Secretary of State, or here, the FTT, has reached a conclusion of fact? What happened, for example? I'm not sure that we can just start deciding questions of fact.
No. What my answer was focused on was the convention question in this case.
Yes.
Which is, has there been an indirect discriminatory effect?
Yes.
If so, proportionality. Now, on the question of whether there has been an indirect discriminatory effect, looking at the general position of those with mental disability as against those with physical disability, in my submission, the court does decide that for itself.
You may be right, but I've not seen any authority
No.
to that effect. As Mr. Moretto said, this is a question which frequently arises in the employment tribunal, because they're very expert at dealing with indirect discrimination arguments, often under the Equality Act, but they can be under the Human Rights Act as well. And I suspect, although I haven't got them at my fingertips, that there must be some authority about. So, for example, the appeal to an EAT is by statute limited to a point of law. And there must be some learning, but I don't know what it says. Whether the EAT can simply decide for itself whether the ET got it right on whether there has been established to be a disproportionate impact and therefore indirect discrimination which needs to be justified. The answer may well be that that's classically a question of fact, and the appellate tribunal can't just interfere with first instance finding.
Well, putting proportionality to one side, which I think we're agreed is a matter for the court, and focusing on indirect discriminatory effect, I think I would accept that if there had been a concrete finding of fact which bears on the evaluation of discriminatory effect, so if, for example, the administrative decision maker, or in this case the First-tier Tribunal, has said as a matter of fact, we find that 55% of users of this scheme have a mental disability, or whatever the relevant fact might be, then I might accept that I'd be stuck with that finding for the purposes of the appeal. But on the question of the evaluation and assessment of facts for the purposes of deciding whether or not there's a discriminatory effect, in that respect, in my submission, the court isn't bound by the views expressed by the administrative decision maker, or in this case, the FTT. And it's perhaps the reason that I've...
Well, isn't that what they're saying at paragraph 60 and 61? We do not, based on the evidence before us, accept as a generality causation is harder to show in mental health injuries than physical health injuries. In 61, it's not been shown. there's any difference in showing causation between those with physical and mental health injuries under the scheme.
That was on the basis of the evidence before the First-tier Tribunal.
Yes.
And in my submission, it was open to the, on a judicial review, it's open to a claimant to say, here's evidence as to discriminatory impact. It's very relatively rare that a administrative decision maker will have conclusively determined the question of discriminatory impact. I mean, if one draws an analogy with the benefits challenges, suppose that the Secretary of State says, well, I don't accept that there's been a discriminatory impact on, indirectly discriminatory impact on women because of this particular set of statistics. That, in my submission, doesn't shut off the Judicial Review Court from deciding for itself whether there's an indirectly discriminatory impact on new evidence.
We may have to look at this further. I'm not sure that necessarily, even if that's right, I'm not sure that necessarily holds good where you have a first instance court or tribunal. I appreciate this is in form a claim for judicial review, but in substance, it's an appeal on a point of law.
Well, my lord, on that point, I respectfully disagree in that although it feels like a cause, the First-tier Tribunal is in exactly the same position as an administrative decision maker because on the claim for judicial review. Now, it may be relevant to the amount of weight that one attaches to views expressed and matters of that kind. But as a matter of principle, the nature of the claim for judicial review can't, in my submission, be different where one's judicially reviewing a First-tier Tribunal compared to a Secretary of State. And if one were to conclude that a finding of fact by on one set of evidence by the First-tier Tribunal precluded the Upper Tribunal on a claim for judicial review for deciding the question of discrimination on new evidence, that in my submission would have potentially radical consequences for the field of, for Article 14, because as I say, the consequence in my submission would be that the Secretary of State could shut off.
No, I think we're at cross purposes. I'm prepared to go with you on the Secretary of State analogy.
Right.
Not sure the analogy holds good, where what this court is considering is in effect an appeal from the FTT, albeit I accept in form it had to be cast in terms of judicial.
Right. Well,
And of course, there are a few number of cases in which you can judicially review a decision of a county court, which is a court on any view.
Well, in my submission, what one calls the decision maker and the precise rules of procedure, the precise constitution of that decision maker is not the decisive question. What matters is the form of challenge and the jurisdiction of the Judicial Review Court. I mean, in the old days, there are all sorts of tribunal. I mean, if one looks through Wade and Forsyth, most of the case law relates to rent tribunals, all sorts of tribunals, but exactly the same principles of public law apply to judicial review of those bodies as they do to modern administrative bodies, in my submission.
We may be going around in circles here. That's right, but it's well established in judicial review that you don't normally revisit questions of fact, it's errors of law.
Well, that I accept. The analogy I'm taking, I agree that I think I've made the submission. If it's right for the Secretary of State, in my submission, it's right for the Tribunal. That was my reply.
All right, thank you very much. Well, there's a lot to think about, so it won't surprise you to learn that we will reserve our judgment. You will get drafts in the usual way. They come with a fierce embargo, which means what it says. So limited distribution to those on the distribution list. We would hope that in the light of the draft judgments, you will be able to agree an order disposing of the appeal and any typographical and other minor corrections that are necessary. If you can't agree a form of order, please make written submissions, short written submissions, and we will make the form of order that we consider appropriate. The eventual hand down will be done electronically and by release to the National Archives, so there will be no need for any further attendance. Thank you very much.
Court rises able.